Welcome to a Practice Pro CPD, brought to you by LAWPRO.
I acknowledge that I'm speaking from lands that are part of the traditional territories of many Indigenous nations across Ontario and Turtle Island. In Toronto, these are the lands of Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. I recognize that many of you may be joining from other territories, and I invite you to take a moment to reflect on the lands that you are on and the Indigenous peoples who have cared for them for hundreds of years. My name is Sophia. I am Communications Counsel at LAWPRO and the moderator today. We have three speakers joining us today who are going to share their knowledge and expertise with us. We're joined by Ian Sinke. Ian is an external counsel to LAWPRO. Christine Stoyanov, she is Claims Counsel, and Leanne Fasciano, who was Claims Counsel and now is my partner in crime in communications and is Communications Counsel also. The program is divided into three main areas of discussion. We're going to talk about conflicts of interest, undertakings, file management from beginning to end. Christine, I'm going to invite you on screen now to talk about conflicts of interest. When the reason we came up with this subtopic for this program is actually Christine, I think a few months ago, reached out to me to say, we're seeing these conflicts of interest cases, claims files come up, and some of them are a little unique. And she shares this with us so we can put out information out there, either in writing or in presentations like this. So that's where we got this idea. So Christine, I will turn it over to you.
Thank you, Sophia, and good morning, everyone. Thank you for joining us today for our session on conflicts of interest. Conflicts are one of those topics that we all learn about in law school and we think we know well, but which still manages to trip up even the most experienced of us. Conflicts can arise in many different ways, sometimes from our own personal or financial interests, sometimes through the people that we work with, and sometimes through clients whose interests diverge. As lawyers and legal professionals, we have a profound responsibility to our clients, the profession, and the public. At the heart of our work is the duty of loyalty, to ensure that our clients' interests are paramount and not compromised by competing demands. Despite our best intentions, even the most experienced practitioners can find themselves facing claims, coverage denials, or reputational harm because of conflict-related missteps. The reality is that these situations arise not from deliberate wrongdoing, but from a gradual blurring of personal and professional boundaries and from a failure to reassess relationships as matters evolve. Today, we will talk about what a conflict of interest means for us, the major categories of conflicts that we face, practical steps to identify, manage, and prevent claims. I'll also review some real-life examples of lawyers who have faced allegations of conflict of interest from their clients, and most importantly, how you can prevent finding yourself in the same situation. We'll also discuss the financial consequences that lawyers can face if conflicts go unchecked. So let's start with the basics. A conflict of interest is a substantial risk that your loyalty or representation of a client could be materially and adversely affected by your own interests, duties to another client, or duties to a third person. The key word is risk. There doesn't have to be actual harm. You only have to have a significant and plausible risk that your ability to represent your client might be compromised. That risk need not be certain or even likely, but more than a mere possibility. In other words, it's not just about, I can't continue because there's a clear conflict, but also would moving forward place my client in a situation where my representation is affected because of competing obligations or divided loyalties. That question should be asked constantly, not just at intake, but throughout the life cycle of the retainer and in all of your dealings with your clients. Now, when we talk about conflicts, there are some key categories we need to keep in mind. The first of these categories is personal interest conflicts, where your own financial or personal interest or that of a colleague or family member clashes with your clients. Think of situations where a lawyer is involved in a transaction that benefits a business that the lawyer has a stake in. The second category is current client conflicts, acting for different clients whose interests directly oppose each other. The bright line rule tells us that we can't represent one client against another if their legal interests conflict. Then we have former client conflicts. Even when a retainer ends, your duties survive. You can't act against a former client in a related matter, even if especially if confidential information from that earlier file might come into play. And finally, the last category is third-party or non-client conflicts. This occurs when outside roles or relationships, such as being a director or trustee, compromises your independent judgment. Even preliminary discussions with prospective clients can create risks if confidential information is exchanged and then forgotten later. Each of these categories demands constant awareness. Conflicts can be subtle, and sometimes just the appearance of divided loyalty can cause problems, both ethically and financially. I'm now going to take you through some real claim examples to demonstrate how these risks can materialize in practice. It's important to remember here that I'm talking about a specific claims example. These allegations haven't had judicial pronouncements on them. And in each scenario where I talk about coverage, it will depend on the particular circumstances of the case and may not necessarily be the same coverage analysis that we have reached in these circumstances. The first claim that I want to talk to you about involved a dispute between a lawyer and the other shareholders of the claimant corporation. The insured spouse held 50% of the shares in the claimant's corporation, but 25% of those shares were held in trust for the insured lawyer. There was no formal written agreement documenting the trust arrangement. The lawyer did various work for the corporation, including but not limited to incorporating it, preparing a minute book, drafting a unanimous shareholder agreement, and acting for it on a mortgage. The lawyer also acted for the other shareholders when it came time for them to sell their shares. The potential claim concerned the thwarted sale of those shares. The sale transaction fell through because the lawyer had suggested revisions to the share purchase agreement, which was intended to document his beneficial interest in the corporation. Upon learning that the lawyer had a beneficial interest and that he and his spouse were going through a divorce, the potential buyer no longer wished to proceed with the deal. The claimant corporation retained independent counsel and alleged that the insured had acted in a conflict, knowing full well that damages could result therefrom. The claimant corporation refused to recognize the lawyer's shareholder status unless certain conditions were met, or the lawyer sold his shares to settle the dispute. Not only did the lawyer find himself the subject of a conflict of interest claim, but given that his beneficial interest in the claimant corporation was 25%, LAWPRO denied coverage for the claim. The crucial issue from a coverage perspective was that the lawyer's beneficial interest exceeded 10%. Under the LAWPRO policy, any claim arising from an enterprise in which an insured lawyer, the lawyer's spouse, the lawyer's law partner, or the law partner's spouse holds a beneficial interest of greater than 10% is excluded from coverage. So even if the courts did not recognize this beneficial interest, the claim was still excluded because the lawyer's spouse also held a beneficial interest of 10%. This exclusion applies not only to current holdings, but also to interests held at the time of the alleged error, omission, or negligent act, or any time thereafter. In this instance, that meant the lawyer faced personal exposure for both defense costs and potential damages. Our second claim also involves a lawyer who blurred the line between his business interests and his professional obligations. The lawyer was a shareholder in a mortgage investment corporation. He was not an officer or director of the corporation. Over time, he acted for a particular client on several real estate transactions, holding the funds from those sales in trust on the client's behalf. The client, who was an active investor, frequently sought the lawyer's opinion on new business opportunities. In what seemed to the lawyer to be a harmless gesture, he recommended that the client speak to the principal of the mortgage investment corporation in which he himself held an interest. The client ultimately invested substantial sums of money and could not recover all of the funds. He then sued the lawyer, alleging that he had failed to disclose his interest in the corporation, that he had misrepresented the safety and security of the investments, and that he conspired with the corporation's officers and directors to defraud him. Both of these scenarios illustrate vividly why lawyers must avoid mixing business interests with their professional work. The lesson here is simple but essential. If you have a stake in a business, do not refer your clients to it and do not act in any matter connected to it. Our third example demonstrates how a lawyer's exposure can arise from the conduct or personal circumstances of staff members. In this claim, the lawyer acted for a client engaged in private lending. The client happened to be the family member of the lawyer's clerk. That clerk not only assisted with file tasks, but also served as a translator and an informal business liaison for the client. The client would communicate directly with the client about investment opportunities and about the details of various lending transactions. The lawyer was aware of the clerk's dual role, but did not take steps to address it. When the client later suffered losses on a failed investment, he sued the lawyer, alleging that the negligent advice had been given and that the lawyer failed to warn of the risks. The lawyer and the clerk maintained that any advice was given in the clerk's personal capacity and as a family member, not as a representative of the firm. However, because of the blurred boundaries between her personal role and her professional position, the court could easily infer that she was speaking on behalf of the lawyer. LAWPRO determined that the risk of an adverse finding was there and ultimately settled the matter, making an indemnity payment under the lawyer's policy. This case underscores an important point. Lawyers are accountable not only for their own conflicts, but also for conflicts involving their employees and associates. A lawyer's tolerance or disregard for a staff member's personal involvement with a client can lead to a claim in which an indemnity payment may ultimately be made, triggering both the deductible and the claims history levy surcharge. In short, the lawyer's professional reputation and financial standing can be affected by a staff member's divided loyalties. The takeaway here is clear. Always evaluate not just your own interests, but also those of your partners, clerks, assistants, and associates. If a member has a personal or financial connection to a client or transaction, it is safest to refer the matter elsewhere. Our last claim involves a conflict situation in which an insured lawyer inadvertently found himself after acquiescing to a client request. The insured lawyer acted for a corporate employer involved in an immigration-linked investment scheme. The arrangement required foreign investors to contribute $1 million and assume roles within the company as part of their immigration pathway. To attract investors, the company's principal requested that the lawyer prepare an opinion letter assessing the likelihood of success of the immigration application. The lawyer obliged, drafting a letter addressed generally to the investors, stating that the application had a high chance of success. The lawyer viewed himself as acting solely for the company, not the investors. He also viewed himself as solely providing an opinion on the immigration aspects of the file and not on the investment itself. However, when the investors received the letter, they understood it as legal advice confirming the soundness of the investment. They proceeded to invest significant funds, which were later lost when the company's principal absconded. When the immigration application was rejected, the investors sued the lawyer, claiming that he advised them negligently and that they relied on his professional assurances. Although there was no formal retainer between the lawyer and the investors, the wording of the letter and the absence of any disclaimer led to an inference that he was providing them with advice. LAWPRO determined that the lawyer was at risk of a finding that he had effectively recommended the investment, and the matter was settled with an indemnity payment made under the policy. The key lesson is that even when a lawyer believes that they act for only one party, their conduct may give rise to a de facto solicitor-client relationship with another. The mere appearance of acting for multiple parties can be sufficient to create exposure. To avoid such pitfalls, lawyers must take care to define, document, and communicate the scope of their retainer. They should also consider how written communications, particularly opinion letters or assurances, may be received by third parties. Beyond the legal and ethical consequences, conflicts of interest can have substantial financial implications. For instance, where a claim or circumstances relate to or arise from an insured providing professional services for more than one person or organization having an apparent or alleged conflict of interest, LAWPRO applies a double deductible. A lawyer with a standard $5,000 deductible may therefore face a $10,000 out-of-pocket expense. Moreover, a paid claim will trigger a claims history levy surcharge, which is $2,500 per year for the next 5 years. And that is only if the lawyer has had no other claims paid in the previous 5 years. So how do we prevent these situations? The best approach is proactive management. Here are some practical tips that can save you enormous trouble. First, conduct a comprehensive conflict check for every retainer. Always perform one before accepting any new client or matter, no matter how familiar the client or the transaction may seem. This includes checking for potential conflicts, not only involving yourself, but also your partners, associates, clerks, and staff. Second, look beyond the obvious. Conflicts often arise in less apparent ways. Consider your personal interests, investments, business relationships, friendships, and family connections. Even indirect interests may create a perception of bias or divided loyalty. If you, your spouse, your law partner, or your law partner's spouse has a beneficial interest exceeding 10% in an enterprise related to the matter, do not act. The professional and financial risks far outweigh any benefit. Third, be cautious with friends and family. Acting for family members or friends of colleagues can lead to blurred boundaries. Communications that seem personal can later be construed as professional advice and be attributed to you. If a family member or friend of a staff member seeks your assistance, have a candid discussion within the firm. If there is any overlap between personal and professional roles, consider declining the retainer. Fourth, clarify the scope of retainers in writing. Document who your client is, and equally important, who your client is not. Clearly outline the scope of your representation in a retainer letter and avoid ambiguous statements in written communications that could be interpreted as extending advice to non-clients. Fifth, continually reassess conflicts throughout the life of the matter. Conflicts can evolve. Relationships change. Circumstances shift and clients' interests may diverge over time. A file that was conflict-free at the outset may develop issues later. Regularly revisit the question of conflicts throughout the life cycle of the retainer. Sixth, address potential conflicts immediately. If you discover potential conflict after commencing work, act promptly. Disclose it to the affected clients, obtain informed consent where appropriate, and where consent won't resolve the issue, withdraw from representation. Delay only increases the risk of harm and liability. Seventh, educate and monitor staff. Ensure that all employees understand the importance of conflict identification and the firm's internal policies. Provide training on appropriate communication boundaries and document management. Your staff are often the first point of contact for clients, and their actions can create liability for the firm. And finally, when in doubt, seek guidance early. Consult the LSO helpline, senior colleagues, or specialists. If you remain in doubt, decline or withdraw. It's much easier to explain why you didn't take a client on than why you did. So to sum things up, managing conflicts is not a one-time checklist item. It's an ongoing dynamic obligation that pervades every phase of a legal engagement, from intake to closure. The duty to your client requires you to constantly ask, am I free to make the best decisions for my client? If the answer is uncertain because of competing obligations, interests, or roles, you have a conflict risk. Each of these scenarios we discussed today could have been avoided with early attention to conflict checks, clear communication, and/or professional distance. Whether it's a personal conflict, an employee's dual role, or a conflict between clients, the risks are significant, not just in terms of professional responsibility, but also financially. We've seen how minor oversights or mixing business interests can lead to major financial consequences, including higher deductibles, surcharges, and even legal fees that you may have to pay out of pocket. By understanding the risks and how to avoid them, you protect your clients and prevent unwanted claims. Thank you for your attention today.
Thank you, Christine. Talking about just deductibles and claims history levy surcharge is terrifying in itself. In addition to conflict, I think one of the things that people forget is when they're acting for friends and family, we're a little bit more lax when it comes to communications that could lead to so many misunderstandings. So there's conflicts. Often we're just not as communicative as we would be or document because we're like, our friend or family is not going to bring a claim. That's not true. We have cases where family and friends do bring claims for exactly those reasons. Like the information is just flowing all over the place. There's not enough documentation. So thank you so much. Those are excellent points.
You're welcome.
We are going to turn it over to Ian now. Ian's going to talk about undertakings. In the last few months, the reason we thought about bringing this topic to you was we got these questions about sometimes there was no undertaking, but a lawyer was stuck between a rock and a hard spot. They had a joint retainer and the clients are giving competing instructions, or there is an undertaking, but it's too simple and it's not clear enough. That's what led us to developing an undertakings checklist, which is now on the Practice Pro website. So Ian, I will turn it over to you.
All right, well, thank you, Sophia, and thank you, obviously, to LawPRO for inviting me to speak today, and for all of you for being present for this CPD. I see a large number of participants, so I'm really impressed by that. And as Sophia mentioned, my name is Ian Sinke. I'm an associate lawyer at the firm of Antony Law, and we're a small litigation boutique in Oakville that deals extensively with LawPRO matters, and we have deep experience with these types of claims. And since I was called to the bar, my practice has been devoted almost exclusively to negligence claims and repair of solicitors' errors and omissions. So before I begin, I should say the standard disclaimer applies, just like Christine noted. Obviously, nothing that I say today is meant to be construed as a representation with respect to any coverage available under the LawPRO policy or with respect to any particular claim file. And, like it says at the beginning of a novel, sometimes, the characters here are fictional. These are based on real claims, but obviously, everything's been anonymized and the details have been tweaked a little. So this is not about any particular claim, whether it's one in the past, in the future, or present. So here's the topics I'm going to try to get through today. First of all, obviously, what is an undertaking? Then why are undertakings concerning from the perspective of lawyer liability? What are some examples of claims that arise from undertakings? How does the LAWPRO policy respond to undertaking-based claims? And then how can I avoid an undertaking-based claim against me, which is perhaps the most important part. So what is an undertaking? There's some statements in the case law about what an undertaking is. An undertaking is an unequivocal promise to perform a certain act. Generally speaking, the unique characteristic of a lawyer's undertaking is that it's a promise given by a lawyer in their capacity as a lawyer, which is being relied upon specifically because the person making it is a lawyer. In other words, the party who's asking you to give an undertaking might not necessarily be confident that something they are asking for would be done if they simply asked the party themselves to do it. So they're looking for some sort of additional security to protect themselves. And that's why they ask a lawyer to give an undertaking. Undertakings obviously are given by lawyers are matters of utmost good faith and must receive scrupulous attention. And so the case law and the rules of professional conduct are clear that undertakings are not something to be taken lightly, but they're going to be taken seriously by the courts. It's important to note this comment here, paragraph 10 from this case. Even if the undertaking is couched in language such as, on behalf of my client, I will obtain such and such, it nonetheless is a personal responsibility of the lawyer. An undertaking given by a lawyer renders the lawyer personally liable, even where the consent of the client to the undertaking is lacking. So it's very difficult to sort of, contract out of or bargain out of liability with respect to undertakings once you give them. Just a little clip in here from the TV show The Office. Maybe some of you are familiar. In this clip, Michael Scott says, "I declare bankruptcy." And then Oscar says, "I just wanted you to know you can't just say the word bankruptcy and expect anything to happen." And Michael Scott says, "Well, I didn't say it, I declared it." I sort of like this clip because it seizes on this sort of non-lawyers' perception of how the legal system works. That there's certain magic words which you can use and just have some kind of effect. And obviously, as lawyers, we know that isn't necessarily true. So just because you use the word undertaking does not make something an undertaking. And conversely, just because you don't use the word undertaking doesn't mean that something won't be interpreted as an undertaking. But all other matters being equal, if you do use the word undertaking, a promise is more likely to be interpreted by the courts as an undertaking. So be careful how you use the word. The rules of professional conduct are very instructive here as well. So there's a few things in there about undertakings, and this was echoed in the case which I showed earlier. A lawyer must strictly and scrupulously fulfill any undertakings given by him or her and honor any trust conditions accepted in the course of litigation. Unless clearly qualified, the lawyer's undertaking is a personal promise and responsibility. Now, the commentary here is very interesting, and I think it may actually be a little contradictory if I can go out on a limb and say that. Because the commentary says the following: undertakings should be written or confirmed in writing and should be absolutely unambiguous in their terms. And then the commentary first says, if a lawyer giving an undertaking does not intend to accept personal responsibility, this should be stated clearly in the undertaking itself. But then the commentary here goes on to say the use of such words as on behalf of my client or on behalf of the vendor does not relieve the lawyer giving the undertaking of personal responsibility. So quite frankly, it's very difficult to put language in an undertaking which is going to relieve you of personal responsibility. Even if you put in that language which says, I'm not giving this is on behalf of my client or on behalf of the vendor or whoever you're acting for, you may still have personal liability exposure on that undertaking. So be very careful. There's a few brief statements here in UK case law as well, which are instructive and sort of lead into the topic of why undertakings give rise to LAWPRO concerns. As officers of the court, solicitors are expected to abide by undertakings given by them, and if they do not do so, they may be called upon summarily to make good their defaults. So obviously, a court can compel you to do what you promised to do in your undertaking. But if that can't be done anymore, or if it could never be done, the case law says where the solicitor does not have it in his power, he may be ordered to make good the loss flowing from his failure to perform the undertaking as loss flowing from a breach of duty committed by a solicitor as an officer of the court. In other words, loss means monetary damages. So if you give an undertaking and you're not capable of performing it, a court is going to hold you liable for monetary damages for whatever arises from that failure to answer your undertaking. So why are undertakings so concerning from a LAWPRO perspective? Well, just to sort of give some context here, obviously it's well known that as a lawyer, you owe a duty of care to your clients. So you have to ensure that you act at all times in accordance with the standard of care of a reasonable lawyer in the circumstances. That's not controversial. And certainly I think the majority of claims that come into LAWPRO are claims against lawyers by their own clients, where the client is alleging that their own lawyer was negligent. But there unfortunately are also claims that come in which are made against lawyers by non-clients. And sometimes those are frivolous, but sometimes they do give rise to liability concerns. And one of the major categories of claims made by non-clients are claims on undertakings. And frankly, actually, I think those claims are usually brought by non-clients because when a lawyer gives an undertaking, it's typically to the opposing party as this sort of additional security, as I mentioned earlier. And as the case law makes clear, courts expect undertakings to be strictly complied with. There's really not a lot of great defenses to an undertaking-based claim. So if the party to whom you gave the undertaking proves that you gave it and that they've suffered damages as a result, there's a strong likelihood that they're going to get judgment against you. So I want to talk now about some generalized examples of claims which come into LAWPRO and which we've acted on as well, which are based on undertakings. One of the most common types of claims arising from an undertaking is an undertaking to disperse funds in a certain way upon closing. So typically, in a lending transaction or a sale transaction, there's proceeds of sale or proceeds of a loan, which will end up in a lawyer's trust account, and different parties will claim entitlement to those funds. And on closing, the funds have to be dispersed. And lawyers will give undertakings to disperse those funds in a certain way, and then parties will take steps in reliance on that undertaking, such as, I mean, the most obvious one is lifting an encumbrance on a property, taking steps with respect to a lease or whatever. So, I'm aware of one claim where a lawyer's client was selling a property and the client reached a side agreement with a third party to pay them a certain amount of funds on closing. And that third party then says, no, I need your lawyer to give me an undertaking that he will pay those amounts out of the closing proceeds. Now, at the time that the lawyer gave this undertaking, he believed that there would be sufficient funds on closing. But then, as so often happens, the closing day arrives and surprise, surprise, there's a shortfall. So now that third party is suing the lawyer, saying that the undertaking has been breached. So that's probably the most common example, an undertaking to disperse funds on closing. But the corollary to this is that lawyers will often give undertakings to hold back funds on closing. And so this situation occurs when there's a dispute as to the entitlement to funds. And often in the course of family proceedings, for instance, where a matrimonial home is being sold, or perhaps a business property or investment home, which several partners have invested in, and there's a dispute as to the terms of their investment or their agreement. Whatever it is, a property needs to be sold, but the proceeds can't be dispersed until the parties settle their disagreement. And so the claims in these cases arise when the lawyer continues to hold back funds in trust, and the parties never resolve the underlying dispute as between themselves with respect to entitlement to the funds. So the funds continue to sit in the lawyer's trust account, and eventually one or more of the parties will sue the lawyer, saying that the funds belong to them. Now, we have good ways of dealing with these claims. Ultimately, the solution is usually to bring an interpleader motion pursuant to Rule 43 of the Rules of Civil Procedure to have the funds paid into court. But those can be expensive. So wherever possible, we try to avoid getting to that point. And I'll speak in a few minutes about some steps you can take to try to avoid getting to that point. We have another file, just briefly, where our insured lawyer gave an undertaking to deliver post-dated checks on closing. And when the lawyer gave that undertaking, he actually believed that his client had already mailed the post-dated checks. But it turns out that the client had not, and the lawyer, of course, could not come up with the checks on his own. You can't create them out of nothing. And so that leads to the potential for liability exposure to the lawyer. Those are some examples from solicitors' practice. Obviously, I think that's where undertakings are most common. That doesn't mean that only solicitors can be exposed to these types of claims. Litigators also can be. And another area where we've been seeing a lot of claims in the past couple of years is in respect of litigation loans. Now, obviously, litigation loans are a tool which have pros and cons associated with them. And it's important to be aware of that. And it's important for your clients to be made aware of that. And I don't want to say that you should never get your clients involved with litigation loans, but there are potential lawyer liability concerns that arise from them. So when you obtain a litigation loan for your client, typically the litigation lender will not just ask your client to sign the loan agreement, they'll also ask you to sign an undertaking. And that undertaking will deal with several things. Obviously, most importantly, it deals with how the funds are going to be paid out on close or when the matter is settled. But secondly, the litigation lender will also ask you typically to undertake to inform them if the client retains new counsel or if they become self-represented. And we have seen an increasing number of claims against lawyers from litigation lenders that arise from these undertakings. The litigation lender will often allege that they were not updated in a timely manner as to the progress of the file. And if they had been updated, they would have had better opportunities to secure their loan or what have you. And this can give rise to liability exposure against the lawyer up to the full amount of the litigation loan. And as you may be aware, the rate of interest on these loans can be extremely high. So that can unfortunately be a very large number. So those are just some examples of claims that we've seen recently arising from undertakings. So how does the LAWPRO policy respond? You've just reported a claim to LAWPRO, which is based on an allegation that you gave an undertaking. How's that going to be handled? Well, the LAWPRO policy actually has specific provisions which deal with undertakings. Part 3, sub F of the policy says that it does not apply to any claim relating to or arising out of any undertaking, agreement, or promise by an insured, the insured, that's you, in which the insured assumes responsibility for their own or another's performance of an undertaking, agreement, promise, or payment of a debt. Okay, that is a little difficult to understand, like most insurance policy language. So to give us some context, you have to refer back to the Rules of Professional Conduct, which we referenced earlier, which said that a lawyer shall not give an undertaking that cannot be fulfilled. And that's sort of the key to this provision. Whether a claim arising out of a failure to fulfill an undertaking is going to be covered will depend on whether the lawyer verified that they were in a position to fulfill the undertaking when it was given. So if you give an undertaking to pay a certain amount of funds out of trust on closing and you have those funds in trust, but then inadvertently, due to a bookkeeping error or whatever it is in your office, the funds are paid to the client, and now the client's taken the funds and left the country, there would be LAWPRO coverage typically for a situation like that, because at the time you gave the undertaking, you had the power and the ability to comply with it. It's just because of some other negligence on your part that now you're not able to. But if you gave that same undertaking when you did not have funds in trust, the claim would not be covered, because in that situation, you're essentially given a personal undertaking to agree to cover somebody else's indebtedness. You're taking a personal risk, hoping that your client is going to come forward and pay that amount. So if the client does not pay, then that claim would be excluded from coverage under the LAWPRO policy. So bearing in mind that claims based on undertakings may not be covered, obviously this is pretty frightening. How can you avoid a claim? Obviously, the goal of this presentation is not to create more claims, but to ensure that people avoid claims. So obviously, the simplest answer would be don't ever give an undertaking. And I wish it were that easy, but the fact of the matter is that undertakings are sort of essential to the practice of law, particularly if you're a solicitor or you're doing any sort of transactional work. You are going to be called upon to give undertakings. So what can you do to give yourself the best chance possible of not being subject to a claim based on an undertaking? And quite frankly, a lot of the things on this slide are really just general principles for the practice of law. I know some of it really ties into what Leanne's going to be talking about in a minute, that these principles can serve you well in other areas of legal practice. So obviously, first off, ensure the undertaking is in writing. Don't give an undertaking over the phone. Don't let the other party set the narrative as to what you're agreeing to do. Put it in writing. Make sure you use clear, specific language as to who the undertaking is given to and what you're undertaking to do. Now, obviously, the biggest issue with undertakings is giving undertakings that you're not able to do, an undertaking to do something which isn't within your power to comply with. So if somebody's asking for an undertaking and you're not 100% sure that you'll be able to do it, you can try slipping in the language of best efforts. Now, obviously, these words are open to interpretation, and there's been court interpretation of the phrase best efforts and what that means. And we can't get into that, in any level of detail. But one thing you can be sure about is that an undertaking which starts with, I will make best efforts, is safer than an undertaking which doesn't. Now, obviously, that depends on the opposing party's willingness to accept such an undertaking, but you can always at least make that attempt. The final tip on the screen here, and this may be a little controversial, a little edgy, but I say here, have a healthy distrust of your client. So let me explain what I mean. Think of it this way. Very often, the reason that the opposing party is asking for a lawyer's undertaking is because they don't trust your client. Because if they really believed that your client was going to do what they want them to do, they would just ask for your client's promise or assuring to do it. So the reason they're asking for a lawyer's undertaking is to provide this additional security. So stop and think to yourself, if the other side doesn't believe my client is going to do this, am I just sort of blindly trusting my client to do it? And perhaps that's another lens or another way of looking at the same point. Are you undertaking to do something which isn't in your power to do? If your client is assuring you backwards and forwards, up and down, that he's going to put that money in your trust account, don't give an undertaking to the other party just on the basis of your client's assurances. Wait until the money's actually in your account, and then you can give an undertaking. And finally, I want to close with this point, and I think this applies not just to undertakings, but to other things in legal practice. Now, if you're in private practice, particularly as a solicitor, you're going to be asked for many undertakings over the course of your career, and you're going to quickly learn that there are certain things which are extremely standard. Undertaking to obtain a discharge of a mortgage after closing or what have you. So if you find yourself involved in a transaction where the other side is asking for a very unusual, non-standard undertaking, something which you've never seen before, your spidey senses should be tingling. Often LAWPRO claims arise from situations where there are serious, shall we say, structural problems with the underlying transaction. And, with the greatest of respect to all of our clients, some transactions just aren't meant to close. And if the only way to get a transaction to close is for a lawyer to give a non-standard undertaking, it just might be one of those transactions. So, and perhaps I'm stepping a little bit out of line here, but let me tell you a secret. You don't have to act on every transaction. And obviously, we all have to feed our families, and in a lot of circumstances, solicitors are only going to get paid if transactions close, and that's a whole other complication, which I know Leanne is going to be talking about when it comes to fees as well. But if those spidey senses are tingling, maybe just stop and think and tell your client that unfortunately you can't represent them on this transaction. And I have seen a lot of lawyers successfully protect themselves by withdrawing from the record. And, I should point out, depending on how much you are going to get paid for the transaction, it can make good economic sense as well. The fees which you forego by withdrawing from the record can end up looking very modest in comparison with a LAWPRO deductible, or if the claim isn't covered, as we discussed earlier, personal liability to you on the undertaking. So thanks for your time and attention. We're going to be doing questions at the end. So just to close off, I'll just mention that I and everyone at my firm, we're very happy to speak to lawyers from any time. If you have potential lawyer liability concerns, you can reach out to us, whether it's in relation to something that I said today or any other sort of area of legal practice. We have a deep experience with assisting lawyers with their concerns, and we'd be happy to hear from you anytime. And we'll take your questions at the end. So thank you very much.
Thank you, Ian. You have a lot of questions. We won't be able to get to all of them, but I've picked a few that are general or repetitive. All right, so Ian, if you can please stay on. Leanne, thank you for joining us. We're going to talk about file management from beginning to end. So we're thinking about retainer to file retention. I'll turn it over to you.
Thanks, Sophia. Can you see my screen okay?
Yeah, it's perfect.
Okay, great. Okay, well, thank you. So file management, it may not sound very interesting, but it's important for you and for LAWPRO because we consistently see claims from poor file management and poor client communication. So I'm hopeful today that the topics that we highlight are going to help remind you of what you should be thinking about as you're working through the life of your file, so that you're taking as many steps as possible to protect yourself from a potential future claim. So Ian and I will be speaking about legal fees and monetary retainers, documentation, and file retention. So the first thing we're going to talk about, first point, is about legal fees. And I'll start by saying that the LAWPRO policy does not cover fee disputes. So that said, why are we concerned about legal fees and making sure that you're getting paid for your work? It's because we regularly see claims come up with respect to unpaid invoices. And I'll put this into context for you by giving you two common examples that we see at LAWPRO. The first example is pretty straightforward. It's when a lawyer sends their account out. The client thinks that the account's either too high or wasn't expecting the amount billed. They don't want to pay some or all of it. And in an effort to negotiate a reduction in those fees, the client says the lawyer was negligent or made errors, did bad work, didn't take instructions properly, whatever they're saying, whether it's true or not. And because of the allegations, they're used as a tool to reduce the fees. But because the client has made those allegations, the lawyer is negligent, it then triggers that lawyer to report to LAWPRO. And then the second example is when a file is completed, the lawyer sends their final account out and that doesn't get paid. And after several attempts to try to get the account paid, the lawyer then decides to start an action for payment or an assessment of its bill. And they are then met with a counterclaim from the client alleging negligence or whatever it is that the client is alleging. And that, because they have the counterclaim, that triggers the lawyer to report to LAWPRO as well. And in that situation, the lawyer may never have anticipated that the client would counterclaim against them. And so it's just maybe not something that they're thinking about or what they would have expected, but it happens. And because they've got a claim now against them for negligence, they report. So Ian, as LawPRO external counsel, what are some of the issues that with these types of claims, and how can our insureds avoid these types of claims in the first place? Like, what kind of things do you see coming up with these things?
Yeah, so thanks, Leanne. We do see a lot of claims with these. And as you mentioned, the most common sort of fact pattern is when a lawyer uh, first tries to enforce their account, whether it's through, for instance, a small claims court action or the Solicitors Act assessment process, and then they're met with negligence allegations. And the reason why this can be so problematic is because generally speaking, lawyers and the claimants as well are looking to achieve a global resolution. We don't want to leave things hanging. And as defense counsel for our LawPRO insureds, we don't want to leave things hanging either. And so in a case where it might have otherwise been possible to achieve a settlement of the negligence side of the claim, it now becomes impossible to achieve a resolution because the lawyer is either, hanging resolutely to their invoice, or because the claimant isn't prepared to accept that they have to pay the invoice. So it creates great complications, and it really increases the likelihood that the claim file will remain open for a lot longer, potentially even head to trial. But ultimately, whether or not the lawyer is even bringing a claim for enforcement of their invoice, the quantum of the fees which a lawyer is charging can still impact a solicitor's negligence claim. It can have effects on how we litigate those. And so we see cases very often where, for instance, a litigator has charged a very large amount of money to a client. And now the case is quite old, potentially now it's up to be dismissed for delay or whatever it is. And the client feels like nothing's been accomplished for the amount of money which they've been charged. And whether or not the client is actually, legally disputing that, or whether the lawyer is, maybe the lawyer's being paid, so they're not trying to enforce the invoice. When clients bring negligence claims against lawyers, they'll very often mention and plead specifically, this is the amount of money I was charged to achieve this bad result. And they feel like they haven't received value for money. And while that in and of itself doesn't prove that the lawyer was negligent, it's not really helpful in trying to establish that the lawyer wasn't negligent. So it's not necessarily about how much you charge, obviously, but I think this is on the slide as well. Details about fees and billing. Discuss things up front. Set the client's expectations right, and then document why you're charging what you're charging. Itemize everything, obviously, because if you render an account and it just says, $10,000, prepare for summary judgment motion, and then you lose the motion and the client is suing you saying that you could have won the motion or whatever it is, that's a claim which we could deal with. But now the client is going to say, I paid $10,000 for this. I didn't get value for money. And that's just a wrinkle or a complication which we just don't need. So, yeah, I'll pass it back to you, Leanne.
Thanks, Ian. So in terms of some tips that we can share with you in terms of what you can do to prevent these sort of things from happening, Ian mentioned about making sure that you're making sure that you're getting a monetary retainer up front. That's one of the things that you want to make sure you do, and make sure that you're speaking to your client about these things, which is what Ian mentioned. Talking about the fees up front, making sure you're putting those things in your retainer agreement, and making sure that it's in writing and that the client is aware of fees going forward. So if you get your monetary retainer up front, you also need to make sure that you're telling your client how that's going to be applied and where that's going to be kept, typically kept in trust, and if it's going to be applied to the last account, or if it's going to be applied to the first account, make sure that you're getting a top up of that retainer. And so that's going to be very important for you. The other thing you want to make sure you're doing is billing regularly. And I know, Ian, we chatted a little bit about this. I think that if you bill monthly, that really helps in terms of keeping client expectations fresh, because it's more immediate, and you'll have a better idea as well of whether you're going to have an issue on collecting any of those fees. So, right? Like
there's a couple of reasons why billing regularly is important. I think number one is that when a client receives your invoice, they may have questions about it. And so if they have questions about it, it's best for you, if it's very fresh in your memory, to be able to answer those questions. If you go 2, 3 years without billing a client and then you send them an account for something which was done a very long time ago, if they ask you questions about it, there's a lot of water under the bridge since then. You're going to have forgotten what went on. You're not going to be able to justify it. And if you aren't able to justify it to them over the phone, the next step might be them, challenging your account. Another reason, and I think it's not so much necessarily about the time period as about, keeping the amount of each individual invoice low. And the reason that we want to do that is because, and again, this goes back to what I was saying earlier. We do obviously, we have to make money. We're not doing this as a hobby, right? But in my opinion, you should always make it so that the amount of money which is outstanding on an account is an amount of money which you're prepared to walk away from should the need arise. Because if your client is starting to, make allegations of negligence against you, it can often be more, financially beneficial to simply walk away from whatever's outstanding on the account and not try to enforce that, whether, in small claims court or by the Solicitors Act process, and thereby avoid a negligence claim against you. Because if the negligence claim does arise, that has to be defended. That could potentially trigger your entire $5,000 deductible. If there's exposure, it could trigger your claims history levy surcharge. You could be on the hook for, potentially something like $17,500 over 5 years. And if the amount of the invoice which you were seeking to enforce was going to be a lot less than that anyway, it could be the worst investment you ever made.
Yeah, it's a great point. So I think, in terms of billing monthly, it helps clients because it's easier to handle in terms of monthly bills as opposed to maybe getting a quarterly bill in terms of the amount. And if you are billing monthly and you're getting your retainer and keeping that till the end, and then you're applying that retainer on that final invoice, the amount that's outstanding will obviously be less than it would have otherwise, which may also help you if you are in that situation where you have to make the assessment as to whether or not you go forward with trying to collect the fees or not, which goes to your point, Ian. So the second point is about your file documentation. Please put everything in writing and keep everything in the file. This is the message here, the key takeaway. The largest source of claims comes from poor communication with clients, and it can be avoided if you take the time to make good notes, document conversations, instructions, concerns, recommendations, questions, answers, strategy, cost to proceed, likelihood of success and risk. Keep all emails, all letters, interim, final reporting letters, everything that you have between you and the client, make sure you just keep it all and keep it all in the file and keep a paper trail of it. If you have a phone call or an in-person meeting, make sure that you take detailed notes of dates, who was there, what was discussed. It's also a really good idea to follow up those phone calls or in-person meetings with a letter or email to the client to summarize and confirm what was discussed, what instructions were given, what the next steps are, who's going to take those steps. Keep in mind you want to be clear, use plain language, be succinct and concise when you're writing to your client. You don't have to write a book. Point form is fine. But the point here is that you want to make sure that you're following up those phone calls and those meetings with something in writing. And this is helpful for you, but it's also helpful for your client because it gives your client a chance to digest the call, the discussion that they just had with you, and it gives them a nice summary to read and reflect back on. And then it also gives them a chance to contact you if there is any misunderstanding or if they disagree with what you've said or what you've said something that they don't understand, if you said something that they didn't say, or if they just changed their mind. Maybe they've changed their mind from their instructions, or they want to speak to you further. So it gives them an opportunity to clarify anything that they need to with you. So don't wait to do this either. Build in time after your meeting or after your call to make your notes and send that confirming letter or email, or at least draft that confirming letter or email. You want to make sure that you're doing this right after, because if you wait to make your notes, you're not going to remember all of the details. Do it right away and then move on to the next file. You're busy, you have a lot of files, a lot of fires to put out. You want to be immediate in this and build the time in. It's not just for the client's benefit. It really is for your benefit. Making those notes, putting them in your file, you're protecting yourself. And if you think about examples like when you're in a closing or you're settling something and you're in the heat of the moment, things are moving quickly, you're getting phone calls every minute, terms are changing, words are changing, everything is just happening very, very quickly. It's hard to take time to make those notes, but those are the times that you want to make sure you do have a notepad close to you and you just take point form notes. Had a call with the client, we changed this term and this is why, and the client was fine with that. So then after, when everything is done, you can then go and put a reporting letter together to the client, giving them the document or whatever it was that you were working on and summarizing what changes were made. This is important because it does come up. It does come up years later with clients. They will contact you and they will ask, well, why did we agree to that many years on a non-comp? Why did we agree to this term? I didn't understand this when we did it. And those actually do form the basis of claims, and I've seen them. And so it's really important when you're in the heat of the moment to make those notes and to take those instructions and make sure that you've got notes of them. You also want to be aware of communicating with your client by email alone. So phone messages, like phone calls, in-person meetings, letters, email, it's all good. You should have sort of a variety of everything. The problem with just emailing your client is that there's opportunity for miscommunication. Emails can be misread or misunderstood. They can be misinterpreted, and that may lead to miscommunication later on. So there is a lot of value in changing things up in terms of how you're communicating with your client. Ian, can you tell us just a little bit about, in terms of the claims files that you've had, where insureds have little to no file documentation in their file, or they have no files at all? What typically will happen on those types of files?
Yeah, thanks, Leanne. As you mentioned, we see a large number of claims which arise in situations where lawyers don't have sufficient documentation of what occurred. And from a litigation perspective, these are always problematic because they lead to what we refer to as a credibility dispute, or in other words, it's a he said, she said situation. And the unfortunate fact of the matter is that overall, overwhelmingly, in cases of credibility disputes, courts will favor the evidence of the client over that of the lawyer. So if the client is saying, we never had this phone call, the lawyer never gave me this advice, or whatever it is, the court will generally accept that evidence. Now, that puts us in an unfortunate position as lawyers, but thankfully there are steps that we can take to protect ourselves. So, and I think there are good reasons why courts tend to favor the evidence of clients. Number one is that as a lawyer, you have many files, and if you're being sued, typically more than 2 years, often significantly more than 2 years after the events of your retainer. There's been a lot of things which have happened in your practice since then. And this is just one out of thousands, hopefully, of files that you have, and you may have forgotten the specific details. But for the client, you only buy a couple of houses in your lifetime, for most people, right? They have very specific recollections of sitting in your office. It's the only lawyer's office they've ever been to. It's the only time they've ever sat across the table from a lawyer and had this conversation. So they very well may remember it verbatim. So, in reality, it is sort of fair that clients' evidence is often accepted over the evidence of lawyers. But there's also a perception that if something was said or advice was given, and if it was important to a lawyer, the lawyer would have written it down. So it's not just that there's a lack of evidence and that the court won't make a finding. It's actually there's almost a bit of a circumstantial evidence which can be taken from the fact that there's no documentation. A court may reason, oh, if this was important to the lawyer would have written it down. Therefore, it either wasn't important to the lawyer or it didn't take place. And so, from my perspective as a defense lawyer, when our insured lawyer clients are being examined on examination for discovery, there will often be this sort of line of questioning, which goes something like this. So, the plaintiff counsel will ask, so in your practice, your day-to-day practice, Mr. Lawyer, if something is important to you, you have a phone call and something important was said, you'd make a note of that, correct? And then this question really puts you in a catch-22 as a lawyer, because if you say, well, no, I don't make notes of important things which happen in my practice, you're just sort of conceding that you're a negligent lawyer writ large. So you can't give that answer. But then if you say, well, yes, if something's important, I do write it down, then you're essentially conceding that this must not have happened because if it was important to you, you would have written it down. All right. So it's a catch-22 situation. Obviously, we do our best to sort of thread the eye of the needle and give an answer which goes, directly down the middle there. But there's really no good way to answer those questions. And that's why these types of claims often give rise to significant potential of liability exposure. Finally, and I know this is on the slide here, I don't know if Leanne, you're going to say anything more about this. It says, don't wait. And I want to mention that making contemporaneous notes and documentation is probably one of the most important parts, and it's often the part which is missed. I had a case, a law profile, where a lawyer was sued by his client, and then after the lawyer got sued, he phoned up his client, tried to record the client's phone call and get the client to sort of admit, in the past, I gave you this advice. That doesn't work. In fact, you're digging your own grave if you do that. You're making the situation significantly worse. The only documentation which counts is documentation which is made before there was any suggestion that you had done something wrong, before you knew you were going to get sued, right? Because otherwise it's just going to be seen as self-serving evidence on your part. So the contemporaneous aspect, quite frankly, I think contemporaneous means the same day. If something happens and you can't do it the same day, but it's the next day, then that's great. And I'll be the first to admit I don't always live up to this standard, which I'm setting for all of you. But there's nothing better than making your notes on the same day. So Leanne, I'll flip it back to you.
Yeah, no, and that's it is really important. You absolutely want to make sure that if you don't have notes, that you're not making those notes in the moment, because if you're doing that, let's say a memo on your computer, that stuff can be traced, right? Like you can take a look at the metadata, you can see when things were created, and so you want to make sure that as you're going through the life of the file, you're just making sure that you're taking those notes when things are happening. And you just have to build that time in, like I said, or just making sure that you've got the notepad and you're doing it as you're going. It really is important. So the last topic is about file retention. So you want to start by having a file retention policy. This helps to give direction with respect to firm procedures and expectations, and it can also address important issues like document review and what to consider when determining when a file can eventually be destroyed. So the Law Society has a sample file retention policy on its website, and that can be used to help you create your own policy. Another resource to review is the Law Society's Guide to Closing, Retaining, and Destroying Client Files. That's also on their website. And they also have a checklist on this topic that can be used. When a file is ready to be closed, make sure that you're taking the time to review the file to determine whether there are any potential issues that are still outstanding and that may have been overlooked. Outstanding undertakings is a really good example of this. Those undertakings can come up years later and form the basis of a claim. I've seen it with real estate claims in particular, personally. So you want to make sure that you're taking a look at everything before you're closing it to make sure you tie everything off and that everything is absolutely done on that file. Make sure that you return any original documents to your client. Clean the file out of any duplicates. Make sure that you're keeping any client identification documents, accounting documents, keep your retainer agreement, any authorizations or directions signed by the client, anything that's signed by the client, keep. And depending on the nature of the file, there may be legal requirements to maintain certain documents. For example, if you have a tax file, there may be some legal requirements to keep certain things. And the Law Society also has certain requirements about what documents need to be retained and for how long. And that's with respect to client identification and verification, books and records, referral fees, and conflict checks. And of course, make sure that you're keeping all the documentation that will help you if you ever need to respond to allegations of negligence or malpractice. So how long should you keep your files? We know that there's no set rule on how long you should keep a closed file for, and it's left to the individual lawyer to determine on a file-by-file basis. But at a minimum, files should be kept for at least 15 years from when the file is closed. That is in line with the ultimate limitation period set out in the Limitations Act. And the data at LAWPRO shows that most claims arise within 15 years. There are some claims that do come up after that, mostly in the areas of real estate, family, wills, and tax. But for the most part, most claims do arise within 15 years. So if you're using 15 years as your starting point, there are a few things that you want to be aware of. You want to make sure that you're building in any additional time for any extension periods. So for example, the COVID suspension period in 2020, the limitation periods were paused temporarily for 182 days during that time. And so you want to make sure that you're adding time onto the period that you're keeping your file for by those extension times. Also, keep in mind that the ultimate limitation period, it doesn't apply to claims involving minors, incapacitated clients, or willful concealment. So if your files involve minors or incapacitated clients, those files should be kept for longer. Also, the ultimate limitation period came into effect on January 1, 2004. So any legal work that was done before that date is deemed to have been completed on January 1, 2004. And so if you did legal work in 1993, it's deemed to have been done on January 1, 2004. And so the limitation period for those claims can't expire before January 1, 2019. That doesn't necessarily mean that you should automatically destroy the files at that point. You want to make sure that you're reviewing closed files to make that determination as to how much longer you should retain that file. And that's going to depend on a number of things. It's going to depend on the area of law. It's going to depend on any relevant limitation periods. It's going to depend on the types of clients, like we mentioned, minors or incapacitated individuals. Any specific client characteristics. Did you have a particularly difficult client? You may want to keep that file for longer. The type of matter, maybe it was extremely complex, and so you may want to keep that for longer as well. And also, how likely are you to represent the client again in the future on a related matter? That would be a good idea to keep that file if you think that that may happen. Ian, is there anything you'd like to add about limitation periods or thoughts on keeping files for at least 15 years? I know it sounds long, but
yeah,
you know,
I do have a few comments, Leanne. I mean, sort of tying this back to the previous topic, which we talked about, which is, keeping good notes, documenting your file. Quite frankly, file retention is all well and good, but there has to be something worth retaining, right? So if there's
Right.
nothing in your file which actually protects you in any way, then it really doesn't matter, how long you're retaining it. So the critical thing is making a good file in the first place, and then the second step is retaining it. Now, there's been a recent case of the Ontario Superior Court, decision of Justice Myers. The case it's called Tesaro and Gora, 2025 ONSC 198. And this case is about the ultimate limitation period. And it's a good case for LAWPRO and for lawyer liability generally, because Justice Myers in that case says the ultimate limitation period does apply to a claim in that case about a lawyer drafting a will. So in other words, if a lawyer drafted a will more than 15 years before the person dies, and then the person dies and a claim arises after that point, there's no possibility of a claim against the lawyer. And so that's where, obviously the guideline on the screen is 15 years or more. But, I'd sort of challenge that a little and say, it's 2025. We live in a digital age. There's really no excuse to be creating physical files anymore in this year. And that may ruffle a few feathers. I see, there's about 900 people on this call. And I think if I were a gambling man, I'd put money on the fact that somebody is going to get off this call and is going to go open a new file, and their law clerk is going to pull out a manila folder and put a Brad in the top, and they're going to start printing stuff off, and that's their file. Because I know that because we have lawyers who have claims against them who we ask for their file, and that's what they still send us in the year 2025. And, with all due respect, in my professional opinion, that's just not acceptable anymore. You should be creating digital files. If you have physical files, they can be scanned in and they can be converted to digital files. And if your files are in electronic form, the incremental cost to keep them forever as compared to keeping them for 15 years is quite literally pennies. It's a very, very small amount of money to maintain a storage service, a cloud storage service, which keeps all of your files essentially forever. And, fingers crossed, you'll never need to refer to any of those. But if you do, it could be one of the best investments you ever make. So I think that should probably be the takeaway is, why are we talking about how many years to keep things when we can keep things forever? We have the technology to do that. I have never seen a claim, never once, where the lawyer had kept their file and I said, oh, it's unfortunate this lawyer kept their file. We'd be in a better position if they had burned this 15 years in or 7 years in or whatever it was. So yeah, those are my thoughts on file retention. Anything
Yeah.
else, Leanne?
Yeah, so I guess, I was thinking about this in terms of 15 years, thinking that some people may think that's a long time, or thinking that, if 15 years is the ultimate limitation period, then why would I keep it for any longer, right? And to that, I I have to say, so a couple of things. One, it is your decision. It's up to the lawyer, client, file by file basis. But the second thing is that I have seen matters where the ultimate limitation period comes into play, and that's a defense for the lawyer. But I have seen those files where the lawyer actually did make an error. And in those cases, more often than not, lawyers are genuinely they're genuinely upset that that they made an error, and that they can't help their client at this point, or because they've got a defense here. And so in those situations, it's great when they have their file, because they can offer their client and their counsel documentation. They can offer them whatever they may need to fix the error, to address the issue. And so I think there's a lot of value in having those files, even if you don't necessarily need them to respond to any allegations against you, or if you have a defense. It's nice to be able to respond to clients and to be former clients and to be able to help them out when they need it. So that wraps up our comments. Really, client management is about communication, and file management is about documenting that communication. And, I can't tell you enough, you will really thank yourself if you have a well-documented file and you ever do need to respond to any allegations of malpractice in the future. Thank you.
Thank you. We had a lot of questions come in. So Christine, I will start with you. This was the question. Do you have any, well, I might have reformed it, but do you have any guidance on lawyers who acted for a client previously and is no longer acting for this client, but wants to be involved with this previous client in other ways, such as giving this previous client a loan, secured or unsecured? Do you have any guidance?
I'd be really cautious about entering into transactions like that, particularly with a former client. You're going to put yourself at risk that the former client might suggest that you recommended doing something in particular or provided them legal advice in connection with the claim, or that you acted in a conflict of interest. I think that in circumstances like this, it's probably best to stay away from it. But if you're intent on proceeding, I would ensure that the former client has their own representation, and it's probably best even to have your own representation so that you're one step removed. It might not necessarily prevent allegations being made against you that you acted in your professional capacity, but it will help to provide an extra layer of protection.
Okay, thank you.
Yeah, if I could just jump in there,
Yeah,
Sophia,
please.
there's also significant risks, not just with respect to conflicts of interest, but whenever lawyers get involved in lending transactions on a personal basis, and there's also exclusions in the LAWPRO policy if a lawyer, for instance, is acting as a mortgage broker. So I know we do see a lot of claims where lawyers are acting on lending transactions with their own money, with other people's money, and for I think it's fantastic that, we're doing well. We have money to lend out, but realistically, to the greatest extent possible, whether former client, future client, present client, you should avoid having those two groups of people, clients and, people who you're lending to, ever overlap.
And just if I may add to that as well, since Ian referenced the exclusions in the policy, this type of situation where you're engaging in private lending to clients would also engage the exclusion that I talked about earlier, because
Yes.
it would fall within the definition of a business or non-business enterprise. So if that client ultimately made a claim against you, asserting allegations in relation to that loan, that may not be covered by the LAWPRO policy.
Thank you. Thank you both. Ian, this question is directed at you, but please, anyone can jump in. In a sale transaction, it's a specific question, but you can answer more generally. In a sale transaction, purchaser's lawyer insists to ask for an undertaking to hold back certain funds because there's some issue. Normal, common, we see it all the time. After closing, the parties don't agree. So now the buyer's lawyer is stuck with holding this amount in their trust account, and there's no resolution that's coming, or not, at least in the foreseeable future. I think this goes back to having a detailed undertaking, which is super important. But say a lawyer is in the situation, it's not a detail, it's a very general undertaking. I undertake to hold back $20,000 post-closing until whatever is fixed in the home. If a lawyer is stuck in that situation right now, do you have any guidance or suggestion?
Yeah, I mean, obviously, this is a situation which we deal with on LawPro claims, and this is something which you can report to LawPro, and depending on, how the situation arose, LawPro may assist with this. And what we do in these scenarios is we bring an interpleader motion pursuant to Rule 43 of the Rules of Civil Procedure to have the funds paid into court. That sort of takes it out of the lawyer's hands, and now it becomes just a dispute between those two parties. But as you mentioned, Sophia, I think the critical thing here is to make it clear in the undertaking what's going to happen if they don't reach an agreement. Have an end date, say 30 days, 60 days, whatever it is, 180 days, 1 year, and after that point, the lawyer is automatically authorized under the undertaking to simply bring an interpleader motion to pay the funds into court. So you can set out that whole process in the undertaking, and you can say, if after 90 days there is no agreement between the parties, then the lawyer will and shall bring an interpleader motion to have the funds paid into court. And that essentially gives you that extra layer of authority and authorization to take that step. Now, ultimately, that doesn't force them to agree, but it does help you if you end up in the situation where they don't agree.
Great, thank you. So say the lawyer has now paid the funds into court. What are the parties to do? Now, this is obviously a broader question. The lawyer on the other side, who's now client, is like, what happens now? What does happen in general? In very short, we're not going to go into detail, obviously.
Yeah, that really depends on the type of dispute. As I mentioned, in my remarks, most often these seem to arrive in the case of family law disputes. So typically, there will have to be an ultimate adjudication of the equalization of property as between two spouses. And so when that occurs and there's a court judgment as to entitlement to net family property, then at that point, the family law lawyers can go and bring an application to have the funds paid out of court. So while they're in court, they sit in the account of the accountant of the Superior Court of Justice. They earn a very nominal amount of interest, I believe, and then they'll be paid out of court. So if you're the family law lawyer or the litigation lawyer, obviously you have to deal with that. And the goal here really is to get these types of contentious matters out of the hands of solicitors, particularly real estate practitioners, who very often, most often, I think, are uninterested in dealing with litigation or dealing with contentious types of matters and would prefer to simply get the file closed and move on to the next one.
Thank you. Leanne, this question is for you. So the question is about having digital files. I think sometimes lawyers think we must have paper files. It cannot be digital. I think Ian clarified that. You can have digital files. There's nothing wrong with that. Are there concerns about storing files digitally that come to mind? I know there's a few that I usually talk about, but Leanne, do you have any concerns that we could share generally?
I think generally you want to make sure that whatever document management system you're using in terms of electronic, you have a backup. Make sure that you have it's secure. Make sure that you have a backup. There are rules, guidance that the Law Society gives in terms of how to store electronic files and things to consider. You want to make sure that it's secure and that that if there is any sort of glitch, that you've got the backup there. I don't know if you have anything else to add to that.
Yeah, I think it's like, where is the backup? Is it like on a local drive in the office where everyone works? What happens if there's a flood or a fire? Is there a backup to that? If it's in the cloud, what cloud service? Where is the server located? What happens if that cloud service goes out of business? I mean, I think those are just considerations.
Yeah.
Somebody in the chat said, as lawyers, we have to be paranoid. But it is our job to think about these issues. So I think that's what I usually ask lawyers to think about. Like, where are you storing it? What is the backup? Is it reliable? I mean, paper files are generally stored in office, right? And there's a chance of flood and fire. I think that's the least safest method, my opinion. We always backed up when I was a private practice. At that time we did have paper files, but we always backed up digitally. And I think we had a local, like on site, but then also in the cloud off site.
Yeah. We did the same, and then we'd scan everything. It would all be paper and then digital, and then after a certain point we would destroy the paper, but because we knew we had the digital. And so but you also know that you've got your backup, how things work, if there is ever an issue. And there's a lot online about on the Law Society about the considerations to take and to how to store things electronically.
Ian, Christine, anything to add?
Engage the appropriate experts. You're a lawyer, you're not a software engineer, right? So get advice from a company that specializes in this. And also, obviously, cyber insurance, which is something which I know LAWPRO has been talking a lot about lately as well. If, back in the day, as Sophia mentioned, one of the major risks and something which we still see is fires and floods, right? Now, it's more frequent, I think, to have claims where the file has been corrupted or destroyed because of a hacking or some sort of phishing attempt. So we see those types of claims as well. And cyber insurance can potentially cover some of that stuff.
Great point. All right, Christine, this question is directed at you. Again, please, anyone feel free to jump in. How do you feel about an employee, say a clerk at that law firm, who wants a lawyer to act for one of their family members, but everyone is in agreement that another clerk will be assigned to that file, and that employee that has that personal relationship to that client will be completely hands-off?
I think you have to be able to assess whether that's actually going to be the case, right? It's really hard for a family member to avoid commenting or answering questions that another family member asks them about their own file. Maybe they won't have any access to any of that information, but they might ask hypothetical questions about the file or divulge some confidential information inadvertently or intentionally to that particular employee in the course of their social events or other family events. And I think it's really, really difficult to kind of prevent that and to put that barrier up. But I think if you do, as I suggested earlier, and you have an internal policy about these things and you educate your staff members, advise them against commenting at all on any of the files where they have a personal connection with the client, then that will go a long way to helping prevent these types of conflicts.
Thank you. Next question is about undertakings. There's two, I want to say short questions, but maybe that's nothing is short. Can a solicitor's undertaking ever expire? So I think this is a question about limitation period if the other lawyer on the file doesn't enforce it. I'm not sure if anyone can answer that. If you're not,
I mean, that's sort of tricky because you know, you can put end dates in your undertakings, but it's really contextual. So there'd have to be some more, you know, information about what you're undertaking to do. Certainly, as long as the undertaking goes unfulfilled, you know, it's a continuing act of default on the part of the lawyer. So I don't think you can simply say, oh, after 2 years, all your undertakings evaporate. That would be far too optimistic and hopeful.
right, thank you. I noted down so many questions to get to, and of course we can't get to them all. Okay, maybe there's one more that it's about conflicts. In our firm, the receptionist or clerk receives initial inquiries from prospective clients, often containing confidential information before having a chance to check for conflicts, right? So they got confidential information before the conflict check was done. If no lawyer or paralegal reviews that initial communication before a conflict is identified, has the firm nonetheless engaged in a conflict of interest?
I think the answer is possibly, right? Because you never know in that circumstance whether the prospective client is calling about a matter involving one of your clients, existing clients, right? What I would suggest is that the receptionist not in fact receive any initial information like that and merely set up an appointment for an initial consultation or have the conflict check run before any information is received about the file. In those cases, it seems like you might run the risk of not having that information properly documented. And then when you are performing your conflict checks down the line, it might get missed. And so I suggest that in those situations, the more prudent way of proceeding would be for the receptionist not to receive any confidential information as part of those initial calls and merely to refer to a lawyer within the firm.
Yeah, I think sometimes there are situations where clients or potential clients just send things off and that gets tricky, but I think that comes down to process about making clear, you know, this is the process. We're going to talk on the phone first. Please do not send me anything. I think that boils down to process. Ian, sorry, you're going to say something?
No, you
Okay.
answered it perfectly, Sophia.
Amazing. So we're almost to end of time at 11. We have a minute to go. So I want to take this opportunity to thank everyone, all the staff at the Toronto's Lawyers Association and LAWPRO working behind the scenes to make today's event run smoothly. Very special thank you to our speakers for sharing their time and expertise with us today. If you have comments and you'd like to share, you want to reach out to practicepro@lawpro.ca. There's only a handful of us that receive those emails. This program is eligible for 1.5 hours of professionalism and for LawPro's risk management credit. So it's one credit, which is $50 off your 2027 policy premium. Talking about policy, your LawPro policy's last date of renewal is tomorrow. Please do not renew and be stuck with a penalty for not renewing on time. The program will be available along with the materials if you have not received it at practicepro.ca CPD page. This ends our program, but please stay on. Myself and our speakers are going to leave, but there's a poll. The poll has 2 simple questions, and it really helps the TLA and us at LawPro prepare for future programs. Thank you so much.